James Brannan from the European Court of Human Rights. I'll just give us a short biopic, for him, just to know who he is and to introduce him. Okay, he's got a BA in French Studies at University of Reading, and then a postgraduate degree in European Law at Lyon University. And he's a legal linguist, currently at the European Court of Human Rights in Strasbourg. In fact, he's been working there since 2005. And he was previously at the International Court of Justice in The Hague. His current post of senior translator consists mainly in translation of the court's judgments from French, attending deliberations to give linguistic advice, editing judges' opinions, revision of outsourced translations, and so on and so forth. His interest in the subject of the presentation, today's presentation, stems largely from his experience as translator and interpreter for the judicial and police authorities in France from 1992 to 2002, and he was appointed, excuse my French, expert per la Cour d'appel de Lyon. I did say, excuse my French. In 2001-12, he gave presentations on language assistance in criminal proceedings at the Trafoot workshops organized by EULITA. Of course, EULITA is the European Legal Interpreters and Translators Association. And he was financially supported by the European Commission, DG Justice. He has recently published an article on the subject in the Cyprus Human Rights Law Review. He's a member of EULITA and the Legal Experts Advisory Panel of Fair Trials International and the Centre de Recherche Interdisciplinaire en Jury-Traductologie. That's it. That's my last attempt with French. Thank you very much.
Thank you very muit's for this warm welcome, and thank you for the opportunity to be here at this very important conference for the launch of QUALETRA. And it's good to see so many familiar faces, and I will try and not to speak too quickly, and I've got a number of slides, quite a lot of subject matter to cover, so I'll still try to deal with it as slow as possible. So, as you probably have seen from the QUALETRA brief, the description of the project, the background for the project is really European law that guarantees language assistance in criminal proceedings. So I will be talking about European law in a very broad sense. First of all, the law supervised by Strasbourg, which is the European Court of Human Rights, as part of the Council of Europe, which has 47 states. And then, of course, the law of the European Union, which is under the supervision of the court in Luxembourg, the Court of Justice of the European Union. And the European Union has only 27 states. So out of the 47 states covered by the Strasbourg case law, obviously 27 of those are member states of the EU. Only 26 are concerned by the directives on procedural safeguards, because Denmark has an opt-out from from that legislation. So the right to written translation in criminal proceedings is definitely part of the Strasbourg case law. There are many findings which say that documents are included in the scope of the defence right to language assistance. Having said that, there's not much case law on the subject, and I'll mention a few leading cases like Kamazinski against Austria, where the main principles are set out. But looking at case law in terms of written translation, the principles haven't really been applied very much or very well by Strasbourg. There are many exceptions. There are many sort of case-by-case interpretations of the relevant provision. And in fact, you may find the Strasbourg case law unsatisfactory, whether you are a professional linguist or a professional lawyer. It doesn't always go very far. But the guidelines are there, and it's on the basis of those guidelines in the case law that the directive was drafted. And some of the wording in the directive, Directive 2010-64 EU, some of the wording comes directly from the Strasbourg case law. I should mention also at this point that when we talk about European law, there are other instruments that might come into play, and these are mentioned also in the QUALETRA project brief. There's the Charter of Fundamental Rights of the European Union, and that's something which doesn't actually provide for translation or interpretation, but it provides for the right to a fair trial. The other directives mentioned in the QUALETRA brief, one is the second step in the Stockholm roadmap, which is the directive on the right to information. And the other directive mentioned is the directive on the rights of victims in criminal proceedings. And that is not actually part of the Stockholm roadmap, it's part of the Budapest roadmap, so it's not the same series of directives, but it's also very important, and it provides for written translation. So the Strasbourg case law is based on two articles of the European Convention on Human Rights. One is the article on the rights to liberty and security, and you can see here it talks about people who are arrested must be informed in a language they understand about the reasons for the arrest and the charge against him or her. And this article actually covers not just criminal proceedings, but it could cover people who are arrested with a view to deportation or removal. It would cover also confinement in a psychiatric institution, for example. So it's not just criminal proceedings, which explains why Article 5 is not mentioned in the directive in question. But nevertheless, some of the rights under this article are certainly relevant for criminal proceedings as such, and you can see here that it would provide for the right to have the arrest warrant itself translated, and it also provides for the translation possibly of the detention order, and these are documents that are mentioned again in the directive. So there hasn't been much case law under Article 5, and as I said, the scope isn't quite the same as that of the directive. This is really the article that's of importance for us. It was on the basis of this article that the court of Strasbourg has come up with most of its case law on written translation. It's confined to criminal proceedings from the very beginning to the very end, the same scope in fact as the directive, and subparagraph A talks about the accusation. We saw charge, this is accusation, but the French word is actually accusation in both cases. And subparagraph E talks about the free assistance of an interpreter. So that's quite important that it says interpreter and not translator, which is unfortunate, but that's the way it is. You can't change the convention. But this has been interpreted by the court to cover documents and pre-trial proceedings for the reasons which will be seen now. At the very beginning of this case law, one of the earliest cases was this case against Germany, and the German government said that Article 6(3)(e) did not cover pre-trial proceedings or did not cover documents in particular, because as we saw, it refers to the assistance of an interpreter if the person cannot understand or speak the language used in court. Well, in fact, the courts in Strasbourg had said that this does not mean that it's confined to hearings, or that it only provides for an interpreter in court. This is just the condition for somebody to be granted free assistance. In fact, if you look at the French expression in Article 6, the language used in court is la langue employée à l'audience, which seems even more specific. The English is a bit broader, used in court is a bit broader than langue employée à l'audience. And the court said, yes, this should be interpreted broadly, and it should cover the entire criminal proceedings from the very beginning, not just the trial stage. So from that case law, which concerned more the cost of the assistance, which has to be free regardless of the outcome of the case, which is the same as the directive, that even if somebody is convicted, they can't be made to pay for their interpreter or translator later on. Based on that finding, in Kaminski it was clarified that this right indeed extends to documentary material. But then we have to ask ourselves, how is that going to be rendered, this documentary material? Will it be translated in writing, or will it be interpreted or translated by sight translation and hearing, for example? And these are all questions that the court has raised without really reaching a definite conclusion, but the conclusion is reached by the directive, as we'll see, which is much clearer as regards written translation. The court said in Kaminski as well that all documents and statements have to be translated or interpreted when it's necessary for the person to understand or to have rendered into the court's language, and that's quite important because it implies that there's a right for the defendant to have documents translated into the language of the court, for example, when it's documentary evidence in favour of the defence. And that's not quite clear from the directive whether that will be covered. So I'm thinking any evidence that the defence might wish to produce in a foreign language, would they have to pay for that themselves, or would the court pay for it? Well, according to the Strasbourg case law, on the basis of an equality of arms, and also under Article 6.3b, which is the right to facilities for defence, then the justice system should also pay for that sort of translation, when it's translation just for the defence into the language of the court, and not into the language of, not into the foreign language. But of course, there is a limit, unfortunately, on how much can be translated. I mean, it depends, of course, on the case, but with a huge case file, and there was one case where the applicants complained that 400,000 pages should have been translated. I mean, the Strasbourg court found that was too much, and it's always found that this paragraph of the convention doesn't cover all items of written evidence or official documents. But it does mention here written translation, so it does admit that in some cases some documents have to be provided as a written translation. Whether or not the document is translated by an interpreter, there's some ambiguity here. It's interpretation assistance in the context of written translation. It's a bit ambiguous, but the word in the convention is interpreter, so the court usually talks about interpretation when it means also written translation. It's sometimes a bit ambiguous. So we come then to the documents that the court has earmarked. Very few documents, in fact, have been earmarked as requiring a written translation, mainly the indictment. The indictment is based on the fact that Article 6.3a talks about the accusation, and so you have charge in Article 5, and accusation in French in Article 6 is the same word as in French for both articles. And this has been interpreted as meaning basically the indictment in the Article 6 context. And Kaminski says, yes, the defendant may be at a disadvantage if he's not provided with a written translation. And this has been repeated in other cases in slightly different form, and it's quite interesting from a language point of view that In the case of Hermie, for example, the court just said that it has to be a translation without saying written translation, and that's because when Kaminski was, the actual judgment was translated from French into English into French. The French translator translated this written translation by traduction. And then in the case of Hermie, which is a French original, the translator was translated back into English and translated traduction just by translation in Hermie, without the word written, which is a bit unfortunate because that's quite a key word in this finding that there's some ambiguity in the case law about whether something should actually be in writing or whether it can be oral. So it's a shame that in Hermie that the word written was omitted by the translator. Anyway, if some of this is a bit complicated, you'll see my paper eventually on the website. The other document that's been earmarked by the court is the judgment, and unfortunately the court has basically said that the judgment could be translated orally as well, the same as for the indictment. If there's an interpreter in a hearing and the judgment is delivered orally and the interpreter interprets, then that is sufficient for the fairness of the proceedings. And all this comes down then to the holistic view that the court takes in regards to the fair trial. If in general the person has received enough information, has had an interpreter, etc., the court in Strasbourg finds that they don't necessarily need translation in writing, and that's why the case law is quite limited, because the court looks at the situation as a whole. The only real sort of quality assurance that the court imposes is based on this finding in Kaminski, that it's sort of downstream quality assurance when the authorities are made aware of a problem. If they are put on notice in the circumstances, then they should provide a degree of control over the adequacy of the interpretation. And this interpretation here, as I said, extends to translation. But this is just to show you that there's a principle of quality assurance downstream. Unfortunately, the court has said that it's not its duty to regulate registers or regulate the systems in different states concerning certified interpreters, translators, etc. So there's no ruling about whether a translator should be registered or in a particular system. So there's no real upstream quality assurance, if you like, in the case law, only downstream, and even that's quite limited. This is a key case under subparagraph A, when a man was charged in Italy, but had gone back to his country, I think it was Germany, and he complained that he didn't receive a particular letter explaining the charges and the accusation in his language. And the Italian authorities refused to translate it for him. And the court found a violation, and the important thing about this case is that the burden of proof is on the authorities, and this was written translation. The burden of proof was on the authorities to show that the man could speak Italian, and the burden was not on the applicant to show that he couldn't. It's quite difficult to prove that you can't speak a language, but it's also difficult to prove that somebody else can speak a language. But the court has said the onus is on the authorities in this case, if there is a request. If there's no request, there's some doubt in the case law about whether the authorities should be proactive or not. And it's quite recently, the court unfortunately has confirmed this view that oral translation may be sufficient, and it said that because the convention speaks of an interpreter, not a translator, oral assistance may satisfy the requirements. And this has been interpreted by the European Commission as meaning that in some cases it may not satisfy the requirements. And that was an important point in the negotiations concerning Article 3 of the directive, that there is some case law that provides guidelines then for the directive, but the directive goes a lot further, as we will see. This is a case where the court eventually decided that the person could speak sufficient Italian and didn't need a translation, but in the first part of the case before the chamber, it identified a complexity test, saying that the document was so complex that the man needed a translation. And this is an interesting sort of test, really, because when we come to the directive, we'll be talking about various tests which will have to be implemented to find out whether a particular document is necessary. And one such test is the test of complexity. To finish with, then, this is to finish the Strasbourg part of my presentation. This is a case about the quality of a written translation, which is not very satisfactory. Again, the court found that in general there was a fair trial. This man was a Lebanese national in Belgium, and there were three problems here. One was the delay, because he'd asked for a translation of the prosecutor's final submissions, which constitutes the accusation, really, in the criminal proceedings. And he waited 15 months, but the court found that there was no problem because he was still awaiting trial at that time. So it wasn't. If it had obviously been any longer, it might have been a problem. But it was quite a long document. But there's a quality problem because it was a mixture of Eastern and Western Armenian, and the applicant said it was incomprehensible. And the applicant himself had it analysed by some experts, professor and translator. And the experts found that it was quite incomprehensible, and they agreed with the applicant. But they also said that he should have understood the gist of the translation. So the Belgian courts and the Strasbourg court found that it was satisfactory because he must have understood the gist. So without going any further into that sort of linguistic analysis. And he also had an interpreter throughout all pre-trial proceedings. So there's a problem of delay, quality, and then quantity, because he wanted a lot more documents that were refused. And then he complained that he didn't have a sufficient remedy for the purpose of challenging the refusal to provide him with other documents in the pre-trial proceedings. And basically, the Strasbourg court dismissed his application and said that the trial court eventually, ultimately the trial court would be the guarantor of the fairness of the proceedings, and at the pre-trial stage he didn't have, he had a sufficient remedy because he was able to complain, but even though he was unsuccessful, he still had some form of remedies. But the important thing was the trial as a whole. Okay. The European Union then started this work on procedural safeguards with the green paper of the Commission back in 2003, so 10 years ago now, and it said, it said that the written translation in the member states was very unevenly provided. There's a lot of variation, but the point was that the proceedings had to be fair, a bit like the Strasbourg court. But the European Commission identified the fact that many of the registers mixed up translators and interpreters, and the Commission found it was important to distinguish between them because of the different skills, the different roles. And then I'm obviously going to leave out all the negotiations concerning the framework decisions, etc. Coming straight to the directive, this is just a summary from the Council of the European Union's press release about the main points of the directive in question. Its strength, then, it identifies written translation as an autonomous and more visible right in Article 3. That there's a right to challenge a refusal. There's an emphasis on quality. We've seen the authorities shall decide on a case-by-case basis. They're obliged to be proactive in providing certain written translation. The defence has a right to request specific documents, and translations must be provided within a reasonable time. And the European arrest warrant is provided for as a special case, in particular into a third language, because the original framework decision for the European arrest warrant provided for a translation into the language of the executing state, but not necessarily of the person concerned, which might be a third language. But its weaknesses, the number of documents are very limited. There's no mention of evidence, for example. Discretion is left to the authorities on a case-by-case basis. There's a possibility of waiving the translation and the rights translation. And the passages which are not relevant do not need to be translated. And there's no procedure to establish the general need for translation, whereas that is indicated under the interpretation article, that they have to establish somebody needs it in general. So you could say if somebody needs an interpreter, they also need a translator, but not necessarily. I mean, somebody might not need an interpreter; they might still need a translator in some cases. And then you have this possibility of oral translation or oral summary. Okay? And the definition of quality is fairly vague. It's associated with fairness, so it's still quite vague. Very quickly, the other directives that I mentioned briefly at the beginning, one is on information, and that has a translation element, and the directive on victims, which also has an article devoted to translations of in writing of information for victims. Now, very briefly, to look into the future, well, first of all, we have the current situation where you can see that very few states actually provide for an absolute right, an automatic right to the translation of documents. And you can see that there are 5 states where there's none at all, according to this research done by Torres Ronken of Maastricht University. I think it basically means that it can be provided on request, but there's no systematic, automatic right to the translation of documents. This may have evolved a bit in the last few years, but and the next slide shows you the different documents that have to be translated in various member states of the EU. A lot of them have written translations of the charge and the indictment, the reasons for detention. Very few have parts of the case file. The letter of right is provided for by the other directive on information. The French bill, which is now before Parliament, it was registered in February, has estimated the cost of the measure by looking at all the possible documents in France that might have to be translated in writing. And this is just the first page of a table where you can see they are expecting this to go beyond what's in the directive itself and would extend to evidence in some cases or statements of witnesses. In other words, the directive is very limited in the number of documents it mentions. There are bound to be other documents that are essential on a fairly systematic basis. And to finish with then, this list of documents is something I've made up to indicate. I know that one of the important things for QUALETRA is to establish what documents are required under the directive. And basically, the charge and the indictment is something that has to be provided automatically. But what does that mean in the various languages? How can these documents be identified in various legal systems? Because it's very different whether it's a common law system or civil law system, for example. And for example, the accusation may be in the form of submissions by a prosecutor or by an investigating judge in continental systems. And so this is just an idea of what could well have to be translated in writing. Okay, so I wanted to keep to the time limit. I think, in conclusion, we can say that the lawyer has a very important role because in the directive, in Article 3, the lawyer has the right to request specific documents in translation. And I think the lawyers should always be aware of explaining the right to written translation to their clients. I mean, ultimately, according to the Strasbourg case law, the judge or the trial court is the guardian of the fairness of the proceedings. So if the lawyers aren't very efficient, then obviously the judges should also keep an eye on what's going on. But I'd encourage, obviously, all legal professionals to study the directive carefully and obviously be vigilant that, for example, the oral exception to written translation is not abused. That's the major point, because there is this oral exception in certain cases. An interpreter can be used instead of a translator, and that shouldn't leave the situation open to abuse in order to save money. For example, the courts may well dispense with written translation invoking that particular clause. So just hope that it will be transposed properly and efficiently and effectively in the various states, and if it is, then it should lead to an improvement in the situation. Okay, thank you very much.
Okay, thank you. Do we do questions now or together at the end? Not too many. Okay. Thank you very, very much for this very, very enlightening presentation, overview rather, of yes, the evolution which led to the directive. Any questions? Okay, thank you.
Can I ask one thing? Can you please clarify? Can you please clarify with regard to the police? What sort of documents do you expect the police to translate?
Yeah.
This slide was very kind of quickly removed, the previous one, so I was halfway through looking at it. So.
Yeah.
And what sort of reports? Like line number 3, report.
Yeah. I think obviously it depends on the legal system, and the documents have different names, of course. But a police report about the offence is something that just describes the offence that's been committed, as far as I know, and that's something which could be translated because it would actually indicate the charge, the offence. A charge sheet as well, maybe just a summary of the charges, but that's something which might have to be translated in writing, and even the statements. I'm talking about the suspect's own statement to the police, even though the suspect knows what he or she said to the police, he doesn't know how that's been rendered in a foreign language. So that's something which will be afterwards, obviously, will be translated afterwards during the proceedings to make sure that it's accurate back into the original language, but just to make sure that it's correct. I think obviously there's not that much that can be required during a police custody situation, because I think in most countries the defence doesn't have access to the file at that stage, so there won't be any sort of evidence that will be translated at that stage. But the basic, as we saw under the Strasbourg case law, I mean, obviously the arrest warrant, if there is one itself, and and possibly a police report or a charge sheet or just a statement of the offence. Okay. That's okay.
Other questions? Comments? I've got one. Okay. Yes, thank you very, very much. It was very interesting, I thought, at the beginning when you briefly commented on the fact that the word written had been omitted by the translator.
Yes.
And have you got an idea why that happened? Was it an omission, you think, or it was the end of a thought process?
It's actually, yes, I'm not here to talk about the actual work we do in Strasbourg, but this is an illustration maybe of one of the things that could cause a problem. Basically the judgments of the Strasbourg court are translated from English to French or French to English, depending on the original language. Because the Kaminski case was apparently from English to French, so the word written translation was translated at the time in 1989, just by traduction and not traduction écrite. So when it came to a later case, the original draft was in French, and the lawyer took the French from Kaminski, which is a traduction, and not traduction écrite, and that was translated back again. So the translator, in my opinion, and I know it wasn't me personally, but it was a colleague, the translator should have realised that this was an important finding of the court from Kaminski, and should have put in the word written and used the exact wording from the original. So either the translator didn't realise that it was a quote from a previous judgment, or the translator thought that maybe the lawyer wanted to use the French as it stood and to be more accurate. Then obviously there's no reason really to translate traduction by a written translation.
Because the idea of written is already implicit in translation, isn't it?
Yeah, it's already implicit. Yeah, it's already implicit in both languages, which is why it's not necessarily a mistake. It's just an indication how a finding can change because of the translation process going both ways. Yes.
I would just to comment to this point, in French it would be totally wrong to say traduction écrite. It would be really, you would be insulted. One would tell to you that it is a pleonasm, which is a terrible mistake in French.
That's right. Yeah. So it's not wrong. It's just.
I think this is one of the reasons why we will have a nice multilingual term base. QUALETRA will develop a nice multilingual terms and be one very important key term.
Because in Italian, for example, translation is often used for interpreting.
For both, yes, okay, that's one.
Translators are even called experts, language experts. You know, there's very much a terminological confusion about this. Okay, that's it. Thank you.
Okay, thank you very much.
Thank you. The next speaker is Michel. Sorry, I didn't ask you the pronunciation of your name, but Michel Hara. Hara, yeah, okay. And he graduated in law from the University of Warsaw in Poland. He's a trainee advocate, active defense counsel, providing legal assistance to accused persons in criminal proceedings. And he's a sworn translator-interpreter, providing interpreting at court trials and hearings. And he also provides translations for courts and administrative bodies. He's also a chief expert at the European Criminal Law Unit of the Ministry of Justice in Poland. In particular, the European Criminal Law Unit of the Ministry of Justice deals with cooperation with member states and EU institutions and directs the efforts to implement EU law. And it has also competence over Directive 2010/64. Okay, thank you.
Thank you very much, Madam Chair. If I could just bring up my presentation. This V1. No? No, sorry, wrong one. This one. No, the one below. Sorry. This should be the one. Yes, that's the one. Okay. Thank you very much. Thank you very much to the ULITA team for having me here, for accepting my presentation. And as you can see, the heading is Quality in Legal Translation, the dual approach from the Polish perspective. And this could raise actually two questions straight away. The first one was pretty much answered already, which would be, why do we need quality in legal translation at all? As was previously said, this has to do with the rights of the accused person and to safeguard the fairness of proceedings in that they know what is happening to them and around them.